Hello everyone, I'm attorney and Professor Kirk Angel, and I want to welcome you to this, our fourth mini lecture on issues in employment law. Today we're going to be talking about the Age Discrimination in Employment Act of 1967. Before we begin talking about the Age Discrimination in Employment Act, however, I want to point out that this lecture is meant to be educational only and is not meant to be legal advice. If you're facing a serious issue of employment law at work, I encourage you to consult an attorney who is licensed in your jurisdiction. The Age Discrimination Employment Act was a reaction by Congress to what was perceived as widespread discrimination against employees over a certain age. So Congress passed the Age Discrimination in Employment Act in 1967, targeting a very specific group, and that group is any individual who is age 40 or older. It's very important to remember that age discrimination only impacts or is only a legal issue for those folks who are over the age of 40. Now, many of you would say, well, Kirk, employers may discriminate against an employee who is very young. That's true, but unfortunately that person would not have a legal action under the Age Discrimination in Employment Act. In addition to only covering employees who are age 40 or older, the Age Discrimination in Employment Act only applies to employers who have 20 or more employees. So if an employer has less than 20 employees, the employer is not subject to the provisions of the Age Discrimination in Employment Act. In general, if you believe that you have been discriminated against on the basis of your age in connection with employment, you have two ways of proving that. One is through direct evidence, and the other is through circumstantial evidence. Direct evidence of age discrimination would include statements, whether oral or written, that clearly indicate that your age, over 40, is the reason that the employment action was taken against you. As you can imagine, that type of evidence is oftentimes extremely difficult to come by. If an employer is intending to discriminate on the basis of age, it's highly unlikely they would say that. Therefore, most employees will proceed under a circumstantial evidence case. With respect to a circumstantial evidence case, the Supreme Court has told us very specific things that we must prove as an employee to win an age discrimination in employment case. First, an employee must show that they are 40 or older. Again, the Act does not apply to employees who are less than age 40. Additionally, the employee must show that they are qualified for the position that they held or the position that they sought. They must prove that they suffered an adverse employment action. And an adverse employment action is an employment action that basically impacts your wallet. So failing to hire you, firing you, not giving you that promotion with a pay increase is an adverse action. Finally, the employee must offer evidence that there is age discrimination that's unrelated to the two previous things. So the employee must offer some other piece of evidence that indicates that the employer was considering their age. So for example, in the termination case, the employee may be able to show that they were replaced by a substantially younger person. This method of proof is often referred to as a McDonnell-Douglas method of proof. And sometimes it's referred to as the burden shifting, because once the employee shows those four things that we just talked about, the burden shifts to the employer to provide a legitimate, non-discriminatory reason for the adverse action that is unrelated to the employee's age. Now remember, most states are employment at will jurisdictions, so they don't have to have a good reason for firing someone. They would just have to be able to state a reason that is unrelated to the employee's age. If the employer provides a legitimate non-discriminatory reason for the action, then the burden of proof shifts back to the employee to offer evidence that the employer's reason for the adverse action is untrue. It's false. In the law, we call a showing that the reason is pretext. If the employee is able to do that, then they can proceed forward with their claim. It's very important to remember, especially in the economy that we are in now, that the Age Discrimination in Employment Act only prohibits age discrimination. It does not prohibit an employer from taking action against an employee, for example, because the employee is making too much money. An employer could say, we're going to cut costs, we're going to eliminate folks who are over a certain pay level, and that could result in a number of older employees being discharged. However, if the employer is motivated by money rather than age, there is in general no violation of the Age Discrimination in Employment Act. Very important to remember that any type of legal claim that you want to file under the Age Discrimination in Employment Act must first be filed with the Equal Employment Opportunity Commission. In general, employees or applicants for employment proceeding under the Age Discrimination in Employment Act have 180 days to file that charge. In some states, some jurisdictions and agencies, that's extended up to 300 days. But you definitely don't want to sit on one of these claims if you believe that you have a valid claim for age discrimination. Thank you, and again, my name is Kirk Angel, attorney and professor.